Welcome back to Beyond the Sign. I'm your host, Landon Ball with the Sears Group at West USA Realty. Today's guest is someone I've had an opportunity to work with alongside professionally and call a friend, Nathan Wente of Wente Law. Nathan and his wife run a local law practice right here in the West Valley, helping families navigate estate planning, trusts, wills, probate, and protecting the assets they've spent a lifetime building. What I appreciate about Nathan is that he brings a very personal and approachable perspective to an area of law that can sometimes feel intimidating. So Nathan, welcome to the show.
Thank you. Thank you.
So tell us a little bit about yourself and how Wente Law got started.
So yeah, just real quick, estate planning and probate is something that I've been doing since about 2021, 2022. Prior to that, I was in criminal law. I worked as a prosecutor, worked as a defense attorney for a number of years, close to 15, in the courtroom a lot. And I just got burned out. I got tired of being in the courtroom, got tired of battling and this, that, and another thing. And so wanted to make the transition. Estate planning and probate had been something that I actually did pretty well in law school. Not that that's a good indicator of success as a lawyer, but it was like the one class I did well in. And so there was some interest that I had with the topic. And so we kind of gravitated to that when I wanted to get out of the courtroom. While I was doing my criminal practice, I was purely a solo practitioner. I did everything by myself, answered phone calls, sent text messages, emails, did all my intakes, went to court. I mean, I was doing everything. The estate planning and probate situation, it's a little bit more, I would say, administratively heavy. And so when I brought this up, having my wife join and assist with answering phone calls and so on and so forth was just kind of a natural progression. And so that's how Wente Law, as it is today, came to fruition.
Nice, that's awesome. And you and your wife run the firm together. What's that experience been like?
Well, so the human side of it is it can be tough working with your spouse. The other side of it is it can be great because you get to kind of share. She gets to share in a side of my life that was largely, kept separate. My professional life as a criminal law attorney was largely separate. She didn't get to experience the things that I experience with my clients on an intimate level. Now, she's taking phone calls, she's doing scheduling, when we show up and we're doing appointments with clients, she's often there. So there's a lot of good, but it presents other challenges that we've also had to evolve and work through working with your spouse. So that
Yeah.
it's the good and the bad, but I would say it's mostly good.
And what do you enjoy most about helping families?
So what do I enjoy most? In this space, especially the probate space, probate kicks in when someone has passed away. So a family is often dealing with huge, overwhelming amounts of grief, right? They knew that this day was going to come, but now it's here. Maybe it was unexpected. And so they're trying to manage that. Being able to step in, both from the probate side and being able to say, hey, I've got you here. I'll make sure that we can do these things and that the court process is correct and that the law is being followed. That's very gratifying to be able to lift that weight from my clients. On the estate planning side, it's also that because of a proper estate plan, you can always avoid probate. So on the estate planning side, it's me trying to help the families hopefully never get to that heavy lifting, never get to having to deal with the grief and then all of this other stuff to try to handle the estate. That can be, I deal with clients on the probate side all the time where it's like they never feel like they had time to grieve. Like they're already funneled into something because something has to be addressed with the estate and they're still trying to process the fact that their loved one is gone. So the estate planning side helps me get in front of that. I find a lot of satisfaction with that. Being able to do the estate planning side, they get to avoid the probate. But at the same time, on the probate side, if it wasn't done right, then I can help there to alleviate that. So it's gratifying to be able to lift these weights from families and make it not quite so heavy.
Yeah. Well, that moves us right into where I wanted to start with this interview, which is the estate planning side of things, which is going to protect the families from dealing with things like probate later on. But, probate's a reality of it, obviously. But when someone hears estate planning, what does that actually mean?
So how someone's estate, like how I would define an estate is it's your stuff. Like when you pass away, everything that belonged to you, that could be, property, and I don't just mean real property, personal property, debts that are owed to you, literally everything that is associated with you as an individual is part of your estate. So when we talk about estate planning, we're trying to make arrangements for your estate to hopefully be simple in transition from one person to another. It also includes, though it doesn't meet the definition precisely, it also includes things like doing powers of attorney. Having a power of attorney in place, both a durable and healthcare, allows hopefully someone from having to do what's called a guardianship or conservatorship, which is a guardianship and conservatorship is a court proceeding to someone's person the same way a probate is a court proceeding to someone's property. And so we try to manage both of those things and hopefully create things and put things in place that make that transition simple when you've passed away or you're still alive, but you don't have the mental capacity to make decisions for yourself.
And I think one common question would be, what is the difference between a will and a trust?
I think the biggest difference is, a will's an instruction sheet that someone creates that is gonna be a document that says, hey, this is who I want to be in control of my estate, and this is how I want my estate divided. And a will, if a probate ends up being necessary, a will is gonna be filed with the probate court 100% of the time. It is a document that is more or less like, hey, this is what I want to have happen with my stuff, and this is how I want it to go, and this is who I want to be in control. A trust, I think it's better to think of a trust more like you would think of like a corporation, honestly. It's an agreement, it's a contract that you're putting into place, and you're actually creating a legal entity when you create a trust. And then you're giving that legal entity property that you otherwise own. You're now giving it to your trust, and then you're maintaining control as the trustee. A will doesn't do that. A trust does. And when people think, sometimes I hear, hey, well, I have a will, so I shouldn't have to have, no one should have to do a probate. That's not true. Having a trust with proper funding where assets are in that trust, when you die, because you didn't own the property, your trust owned it, a probate's not necessary because your trust doesn't die with you. So the probate court doesn't need to get involved. A trust can do that. A trust is a vehicle that allows an estate to avoid a probate. A will by itself won't avoid probate if the person has certain assets in their name that are going to require a probate. So that's the biggest difference is that, it's a will serves a very specific purpose. A trust can serve a wider purpose. Doesn't mean that if you don't have a trust, you absolutely are going to have a probate. That's not necessarily true. That's too simplistic of a question. But a trust does allow, properly funded, an estate to avoid a probate and more flexibility or longevity in how assets are distributed versus a will, which is a one and done thing. It's this is the instruction. This is the way it's supposed to happen. Make it happen.
And is it pretty common that people would have both?
Yeah. Yeah. In fact, I think it would be a mistake not to have both because what you see, and I mean, I see this pretty regularly, is someone had a trust but because they didn't fund the trust properly while they were alive, they then pass away. And because that asset is not properly in the trust, a probate ends up being necessary. In that scenario, we most commonly create what we just kind of call a pour over will. It's still a last will and testament, but it's kind of in the trade, we call it a pour over will, with the idea being your will, instead of directing that your assets go to Jim and Susie and Bob, instead your will says, no, I created a trust during my lifetime. Oops, everything should have been in the trust. Something got messed up, didn't get into the trust. So my will directs that I now want everything to go into my trust, and my trustee will distribute it according to my trust terms. So yeah, you would definitely want to have both. And to not do both I think it's a mistake because you're creating a situation where you create a trust, but if it's not properly funded and then you die, you then are under the rules of intestacy. under the state, which is the government is going to say, the law, the legislature will say, okay, well, this person didn't have a will, so this is who's entitled to this estate asset.
So when we're consulting or someone's listening to this podcast perhaps and says, you know what, I need to get my estate in order. Where do you start? I mean, what's the first step?
Yeah, I'm generally the big things I'm going to focus on are, what are they married? That's going to be a big one. Are they single or are they married? Are they, do they have kids? And are those kids biological children of the spouses? Are they kids from a prior relationship? Dialing in kind of the family dynamic is going to be one of the big focal points. Another big focal point is going to be basically, I'll just call it their asset portfolio. People that don't have, a high net worth. And when I say high, I mean, if they own a home, basically, if someone owns a home, and more, I'm going to be looking at, okay, this is going to be somebody I'm going to at least keep a trust in the running. Does that mean someone who has a home has to have a trust? No. Does it mean that people without a home shouldn't have a trust? No. But as their assets grow and also how many people they're trying to provide for, those two categories I'm looking at closely to determine, okay, does it make sense to have a trust-based plan for this person? Does it make sense that, no, you know what, their asset portfolio doesn't justify a trust? Probably you could achieve what you're looking for by, doing a will-based plan. It really comes down to kind of their assets and their family dynamic and what their plan is for distribution. Those two are the biggest driving forces, I think, in whether I'm going to recommend that someone could be fine with a will-based plan or if it would make sense to have a trust-based plan.
So what I hear you saying is trusts aren't just for wealthy people.
No, they're not. No. Now, I will say that as someone's wealth grows, the probability of a trust being the better estate planning vehicle is higher. But you could have a very middle of the road financial family that, maybe they have a mixed family. They have kids from prior relationships. They own a home, they have some assets. Maybe their net worth is in the half a million, range, quarter a million, doesn't really matter. And they have a distribution plan where they want several people to get different things and maybe there's some tension in the family. Well, probably I'm going to be saying, yeah, I think you guys should consider a trust. Do they have to? No. But those trusts tend to be the better vehicle for mixed families, particularly if there might be tension there. They're often a better vehicle to keep estate planning things from being really contentious after, of course, the person passes away, the person who created the trust.
And so my question is even for just protecting your assets. So do trusts have those types of protections when you own real estate?
Yeah. So the simple answer is, yeah, there are trusts that can have that protection. I would tell you that the vast majority of estate planning, families that need estate planning, most of them are going to have what's called a revocable trust. And that trust, its primary objective is to avoid probate, minimize conflict and make sure that assets are getting to where what are called the settlers or the grantors, the people that made the trust, where those are supposed to go. Your normal run-of-the-mill revocable trust that's grantor controlled isn't going to have, when you say protection, and when I get consultations with people all the time, they have this idea that, okay, I need to have this trust, and if I have this trust, I'm going to have this asset protection. It doesn't carry with it asset protection. Your typical grantor funded trust, revocable trust, it's not having the kind of asset protection that I think what you're talking about, what most people are talking about when they say it's protected. It's protected from someone having to do a probate and having to go to court and deal with that. Yes, if it's properly funded. But if, a grantor, someone who creates a trust, they're out in an accident, they get sued, and they get sued for more than their insurance policy, they can still come after your house even if it's in your grantor or revocable trust. It's not going to protect it from your creditors. Okay, the person who created it. There is creditor protection for your beneficiaries potentially, depending on how the trust is set up. So in other words, if you now pass away that asset is now in the trust, there's potentially protections in that trust that would stop a creditor who you've named as a beneficiary, those creditors from coming after the trust inheritance for the beneficiary. That part's true. In order to have like protection, asset protection for what you're talking about, somebody's like, hey, I don't want to lose my house if I get sued. Well, then you're graduating into concepts that deal with like LLCs, irrevocable trusts, and things like that. But that's not inherent in just creating a trust that it magically provides asset protection. That's not real.
That's good. That's good to know because I think that's a common misconception out
Yeah,
there.
I think it is too.
All right, so we talked about, a lot of ways obviously to for families to do the estate planning and put things in place to protect their own assets from probate, but it's life and sometimes you get a property and it needs probate. So let's talk about probate. What is probate in simple terms first and foremost?
So probate is the court proceeding that has to happen in order for someone to gain control, like legal control over the estate, right, of somebody who's died. Remember, we talked about the estate is literally people's stuff after they're gone. If they have certain assets that are just in their individual name and then they pass away, those assets are going to require a probate. The most common one that I see as a practitioner is a house. So if someone owned a house in their individual name and they pass away, almost always a probate is going to be required. There are some exceptions to that, but I'm not going to belabor that. I think it's easy to just look at it as a house is going to require a probate. Financial accounts often will require a probate. And that probate proceeding is someone's going to court and saying, hey, I'm an heir or I'm someone mentioned in a will. I have been given the authority to do this. The court looks at it and says, yes, I agree. No, I don't. They're appointing somebody to be the authorized representative for the estate. And then now that person has court authority to deal with the assets of the person who's died. So now that allows them to get the house and redeed the house to somebody or sell the house. It allows them to gain access to the bank account or the retirement account or whatever. Without that probate, there are certain assets that they're never going to get access to without it. And so that is as simple as I can describe what is a probate.
And when a probate is necessary, what should families know? And I guess to expand on that, who has the right to file a probate? Is it really anybody that's an heir? And then how does the proceeding go from, like, if they get the house? Well, how does the proceeding goes as far as when it's sold and the proceeds are divided? How is it found out who all is involved to collect proceeds?
Okay. So who is supposed to be in control is going to be a product of whether there was a will or not. If there was a will, 99% of the time, any good drafted will is going to have the name of a person or persons who's supposed to be that authority figure, right? It's the will creator nominated someone to be the executor, personal representative. These terms are used interchangeably. In Arizona, it's called personal representative. So the will is going to articulate that. If there is no will, then it goes back to that concept that I said earlier about intestacy. State law is going to control who has priority to be the authority figure for the estate in that equation. So who has the authority is going to vary depending on whether there's a will or not. Sometimes it could be, if there's no will, it could be a surviving spouse. If there's no surviving spouse, you're looking at children. If there's no children, then you're looking at, potentially a mother and father. Like it can spread far and wide depending on the circumstances. And then, okay, now we've established who the authority figure for the estate is or should be. Now, what happens with the stuff, that is also going to be a product of, well, was there a will? Because if so, the will should say who's supposed to get what. If there wasn't a will, then we're looking at the intestacy laws. If there's no will, who's entitled to the stuff? And you're looking at now, the heirs of the estate. So spouse, children, grandchildren, great grandchildren. If there's not those things, then you're looking up. You're looking at mom and dad. You're looking at siblings of the person who died, and then down to nieces and nephews. it's highly variable on any given estate, who's going to be in the position to be in control and who the heirs are going to be for that estate.
And what role do you as the attorney play in helping make that process smoother?
So, fortunately, so Arizona kind of has two different probate processes. They have informal and formal. Most probates can proceed informally, where there's not going to be any fighting. If there's not going to be any fighting, then there's just going to be a lot of paperwork. There's going to be deadlines. The paperwork has to get submitted to the court with completed correctly. Once that person is approved of being the personal representative, legal notices have to go out. Uh, Proof of notice has to get filed. You have to do notices to creditors. You have to publish notice to creditors. You're taking an inventory and sending that inventory. There's a whole line of legal requirements that are required of somebody who becomes the appointed representative for the estate. My job in that scenario is I'm coming in, I'm doing a lot of it, not all of it, because remember, I'm not the personal representative. I'm not the one who's actually given the legal authority to do all of those things in most cases. It's my client. So they have to do the legwork because they're the ones who were court ordered to do it. But I kind of, I'm the smoothness that says, hey, this is what we got to do. This is the timeline we got to do it. And a lot of those things I'm already doing. They give me the information, I do it. Many of those things, not all. So like I'm helping do the notices, I'm filing documents with the court, I'm publishing notice to the creditors, I'm sending notices to the heirs that this has all been done, you know. But like for instance, an inventory has to be taken. Well, I'm not the I don't know. I don't know what property is in the estate. So I have to rely on my client to give me that information. They give me that information. I make sure the inventory gets to the right people and proof that it was done gets sent to the court. Right. So once you've done all of this stuff, and then a lot of other things, clients will call me and say, hey, Nathan, I got this going on. How they're telling me this, what's going on here. Yeah, this is how you need to handle this, or this is how you need to handle that. There's been times where I'll get on a phone call, with a client with somebody who they're having a problem dealing with collecting assets, and I'll talk to the person who they're having a problem with. But that's pretty rare. But it's that smooth part where it's like they don't know court, they don't know what paperwork's required, they don't know all the legal requirements. Well, I do, and many of them I'm just doing, and they never it's not anything that they have to worry about because I handle it behind the scenes while they're doing what I think is the more important stuff, which is dealing with grief, making sure all the assets are collected, communicating with whoever the other heirs are. Because that's really the human side of it. I try to take the non-human side, the bureaucratic administrative nonsense that comes with the probate, and try to pull that away so they don't have to be stressed about deadlines and this, that, and another thing.
And if there's other creditors, let's say there's high debts, or are you able to help negotiate those on behalf of your clients?
Yeah, I can. It depends on the estate, depends on what the client wants, but that is something that we can get involved in.
Well, Nathan, thanks for joining us today. For anyone who's looking to get in contact to start their estate plan, has a property that they have to do a probate, or maybe they just have questions, how can people get in contact with you?
Well, we're online. They can find us online. They can email me directly either through our website, or our email is wentelaw@gmail.com. They could call our phone number, 480-640-3584. That phone number is going to take them right to Lindsay, and they could schedule a consultation with me. And typically our consultations are complimentary, the first one, in most cases, not all, but in most. And they would know that it's not going to be a gotcha,
Yeah.
like that. It's not going to be like, oh, congratulations, you got signed up for a consultation and now here's your bill. They would know that going into it, whether there would be a bill, and they can decide whether they want it.
I think one of the biggest takeaways from this conversation is that estate planning isn't really about legal documents. It's about taking care of the people that you love. The goal isn't to prepare for the worst, but to create clarity, reduce stress, and make sure the family is protected no matter what life brings. If today's conversation sparked questions about trust, wills, estate planning, probate, or simply getting your affairs organized, Nathan and his wife at Wente Law are incredible local resource right here in our community. We will leave their information below in the show notes. As always, thank you for tuning in to Beyond the Sign. If you found today's episode valuable, be sure to like, subscribe, and share it with someone you know and that could benefit from this conversation. Real people, real conversations with real value. See you next time.